Hi, welcome. I'm Neil McGrath, and this is my wife, Ann McGrath.
Hi.
And we're here representing Estate Planning 567. And our goal with this short amount of time we have together is to give you actionable steps you can implement, perhaps on your own, maybe with your current advisors and attorneys, or with us to help protect your estate from unintended consequences. My wife and I have been providing estate planning seminars for many years now. We typically do them in person, local to the Pittsburgh area. However, we wanted to produce something that we could share with a wider audience, and that's why we're here today. So, what I'd ask you to consider, you took the time to dial in, so to speak, to listen to a couple folks you probably never met, to learn about death and taxes, which by the way means you're our kind of people. But we just want to make sure you get what you need out of this meeting today. So there will be an opportunity if you choose to meet with a member of our team individually to get your questions answered. We'll cover more of that towards the end. But again, the number one priority today is to make sure that you get some great information. Ann will come back into the presentation shortly, but I'll get us started with the agenda and some basic information of who we are, what we do, and the types of clients we serve. Thanks, Ann. As I mentioned, we are in the Pittsburgh area. My name is Neil McGrath. I run a wealth management and tax planning firm in the Pittsburgh area. Again, we have multiple locations, and we serve primarily individuals who have complex situations and see the value in having a comprehensive plan where not only their estate planning is addressed, but also proactive tax strategies and investment strategies as well. My wife, Ann, works for a firm here in the Pittsburgh area called the Estate Planning Centers. All they do is estate planning. She is the sharpest estate planning attorney I know in 3 states. We have multiple professionals on our team. There's really no area of concern you have that most likely we haven't seen as a team and can't help address. So I only share that with you to let you know you're in a good place to get really good information. Here we are again. We live just outside of Pittsburgh. We have 3 young children. I've been doing this for over 25 years. And again, serving folks just like you with the concerns you have. My wife has been an attorney for over 20 years, and all she does is estate planning. And we really think it's very important when you are creating your own individual estate plan to have an attorney who specializes in that area of wills, trust, and tax planning. And most importantly, to have all of your professional advisors on the same team. Our clients love the fact that they can meet with us in one conference room and have all of these areas addressed. We do have 3 young children. Coleman is our oldest. He's 12 years old. Nora is 8 and Gabriel is 6. We understand the needs for families who have children to have the right type of estate plan in place. Our oldest happens to be a special needs child, so we also have expertise personally and professionally around special needs planning. If you're like a lot of clients that I've had over all these years, estate planning is one of those things you just continually push off, and it's understandable. Who wants to talk about death? But it's really not difficult. And the fact that you're here today means you want to take some steps to proactively protecting your family from those unintended consequences. So what are we going to talk about today? We believe comprehensive planning should really be the foundation for any good estate plan. So we're going to walk you through those different steps of a comprehensive plan and how estate planning specifically fits into the overall financial strategy for your family. And again, we'll give you an opportunity, if you choose, to have a short conversation with a member of our team to determine if you would like to take advantage of a complimentary meeting in one of our offices or virtually. So, what is the value of comprehensive planning? Well, if you're a lot like a lot of folks, you may have dialed in again, so to speak, to listen to us talk about the difference between a will and a trust, or what's a living will, or what's a power of attorney. We're going to cover all of that information. However, we think that you will be best served by understanding how these different areas interact with each other. So every client, every potential client I've ever met with, whether they had $50,000 or $50 million, has these four concerns. Number one, they don't want to run out of money. So the way that my wife and I work together is, first, let's make sure that you're going to be okay before we create this complex estate plan. Let's make sure you're not going to run out of money. Number two, they want to make sure that if something happens to them, they have the right health care in place, or if they're married, that their spouse is going to be okay. That's part of estate planning. Number three, they want to minimize taxes proactively. And that's a lot different than looking in the rearview mirror and saying these are the deductions, exemptions, or credits. The type of tax planning we do as it relates to estate planning might involve things like gifting or Roth conversions, or some charitable planning that we do. But minimizing taxes is a core component, not only of any good estate plan, but any good financial plan. And finally, while you're here today, to make sure you have the right level of planning in place. And estate planning is not just for the super wealthy. Trusts are not just for the super wealthy. If it's important to you, for example, if you have young children, to have the money distributed at different intervals or to protect those dollars, that's a type of trust. There's other trusts to protect some of your assets in some cases from things like nursing home or long-term care costs. There's other trusts to help bypass probate. And then finally, trusts exist to keep your assets in your bloodline, so to speak, and protect your legacy from things that happen to all of us sometimes, like divorce or litigation or bankruptcy. So believe me, trusts are just not for the super wealthy. We'll cover all of those areas. Again, you're in a great place to get really good information by having an estate planning attorney and a financial advisor with multiple CPAs and other professionals on his team to provide you this comprehensive approach. So again, you may have just come here today to understand the difference between a will and a trust, but we're going to give you a lot more information, a lot more value for your time spent. Hang in there. We'll be together for a relatively short amount of time. If you like, there'll be links to get more information, to get a copy of the presentation, and to meet with a member of our team. So why an estate plan? Well, there's all kinds of reasons to have an estate plan. Obviously, you're here today because it's important to you to make things easier and better for those that come after you. Let me give you a couple examples of very different scenarios that required their own particular estate plan. My mother came here in the 1970s from a developing nation, worked hard all of her life to accumulate $200,000, which to her was more money in the world than she ever could have imagined when she was in Trinidad and Tobago growing up. However, because she didn't have the right estate plan in place and healthcare planning in place, all of her life savings was destroyed within about a year and a half from long-term care costs. We want to give you some ideas on how to protect that from happening to you. My wife's father, who happened to be an attorney, also passed away. And even though he did a lot of great planning, there were certain provisions that he did not account for, such as who gets his class ring, which one of his 8 children gets his class ring, or his watch. And to this day, when we get together as a family, there are negative feelings if one of those children wears their dad's class ring or watch because the other one thought that they should have received it. So there's a lot of reasons to do an estate plan, taxes, but other simpler things like who gets my personal possessions as well. And most people simply don't do it. The vast majority of the country does not have an estate plan in place. You're here today because you know that's important. In fact, the percentage of adults who do not have an estate plan is 67%. 2 out of 3 people don't have a plan for something that's absolutely going to happen to all of us. So we're here today again to provide you some actionable steps to protect you in all of those areas. We believe planning provides that blueprint for success. The next part of the presentation is going to be done by my wife, Anne, who again is an estate planning attorney, and she's going to talk about a lot of the information that you most likely came here for today. And then I will provide some additional detail around how estate planning coordinates with any good investment and tax and protection plan. Anne?
Thanks. Hi there. Today I'm going to discuss with you the 2 main vehicles for estate planning, a will-based plan or a trust-based plan. Think of a will-based plan as a list of instructions, what you would like to have done with all of those assets that you've worked so hard for over your whole lifetime. When you do a will, you go through and you list what you would like to have done. You name a person, a trusted person, who can carry out your wishes. At the time of death, that will is then taken to court and goes through a process that we call probate. A probate is when you ask the court to allow your executor to distribute your assets as you've listed. Your will becomes effective at death, and in there you can also name the guardians for children, who you would like to have certain assets that you have. I like to think of a trust-based plan as a treasure chest. Imagine I put a treasure chest on the table in front of you. That chest can only protect that which we put into it. What will we put into the treasure chest? Your home, your bank accounts, cash-based assets, things that we can retitle and put into the treasure chest. So you still have full authority over these assets. You still own them. You can buy them, sell them, trade them as if you did it today, except you would be doing it as trustee for the Jane Doe Revocable Living Trust. Some great things about a trust are that it is a private document. You don't have to share it with anybody. It doesn't have to be recorded with the courts when you die. It's confidential, as opposed to a will, which becomes public once you pass away and it is going through the probate process. What are the pros and cons of a will? The pros. A will can be drafted pretty quickly. It's a relatively simple, easy to understand document. And you can avoid any intestacy laws in your state. Here in Pennsylvania, the intestacy laws are pretty severe if you die without a will. With a trust, the pros are you can do immediate distribution. That person that you have named to step in for you as your trustee when you die has immediate authority of any and all of those assets that we have put into that treasure chest for you. It is a private document, as we've discussed. Some of the cons of a will or a trust-based plan. With a will, you'll have probate. What is probate? Probate is going to the court, asking them for permission to distribute your assets as you've wished. Probate can take anywhere from 6 months to 2 years or even longer, depending on the court system and the level of complexity with your estate. What is included with probate? So you have to petition the court. The court has to approve the will in the petition. You have to notify creditors, advertise in the newspaper, notify any beneficiaries, pay taxes, identify all assets, and then eventually you get to distribution. That can take some time. The cons for a trust. It takes longer to establish, and that's because instead of finding all of your assets after you pass away, like we would do with a will, we do that beforehand. We get all of your assets together, and those that we can retitle to your trust, we do that. And those that can't be, we make sure that all beneficiaries are listed and up to date, listing your loved one or your next of kin as your first beneficiary, and the trust as a secondary beneficiary. With our will-based estate plan or our trust-based estate plan, we include a number of additional documents. Some are legal documents, and some are documents that are there to help your family and your loved ones once you're gone. The first one that we include is a financial power of attorney. This is a document that allows someone to step in and pay your bills when you are incapacitated. We also include a healthcare power of attorney and living will. This is who can make those decisions for you when you can't do that for yourself, and also includes those end-of-life decisions that you would like to have followed when that time comes. We also do a HIPAA authorization, which allows those that you name to be included in conversations with your medical team. Who can call the nurse's station if you're in the hospital and get an update for you? Who can be part of the conversations with your doctors? This document does not confer any decision-making authority. It more just allows those that you name to have access to your medical information. As I discussed with a financial power of attorney, that comes into play when you are incapacitated. So the question becomes, what is incapacity? Well, that we define in the document. Someone is considered incapacitated at any time they are unable to effectively manage their finances or property, whether that's because of age, mental illness, disability, substance abuse, or any other cause. It's possible for someone to regain their capacity. In this case, that would be established by a doctor submitting a written opinion that the person is now able to effectively manage their affairs. Who determines incapacity? Well, we have some options. We can draft it so that it is 2 licensed physicians that get to determine whether the individual is incapacitated. A court can determine incapacity, or incapacity can be determined if someone disappears for a number of days, weeks, months, or they're just absent and their affairs need to be attended to. In your durable power of attorney, this is your financial power of attorney. Who can step in and take care of your finances when you're unable to? There are 2 ways that we can do this. First, what we have is a springing power of attorney. This power of attorney grants financial access to whomever you name in the event of incapacity or illness. So it doesn't take effect until that time. So even though we execute the document today, that person that you name does not have any authority until you're incapacitated. We could also do what is known as an immediate power of attorney, and this becomes effective immediately. Sometimes you're not sure what you would like to do. In that case, we would do a springing power of attorney with a provision that allows you to authorize access to your financial powers in the event you're going out of town. Lucky you are going for a 6-month safari to Africa and you need someone to pay your bills. We can sign a letter of authorization allowing that person to step in and handle your finances for you. What powers do we give your power of attorney? We give them the power to buy things, sell things, manage any contracts or real estate that you have, operate your businesses, take out loans, or pay back loans. Your healthcare power of attorney and living will is a completely separate document. This document, you would name an individual. It can be the same or a different person as any other nominations that you make. And with this, that person gets to step in the event that you are unable to make medical decisions. It does not have to be end-of-life decisions. For example, if you're in a car accident and you may need a surgery and you are unable to make that decision at the time, who can step in, talk to the doctors, and make that decision for you? When considering who you would like to name as your healthcare power of attorney, you want to pick someone who has the ability to understand and converse with doctors in a meaningful way so that they can make a proper decision for you. With a living will, which we combine with our power of attorney, that is end-of-life decisions. And with that, when we come together again to sign your estate plan, we talk about different end-of-life decisions that you would like done. Whether you would like artificial hydration, artificial feeding, do you want resuscitation? Those end-of-life, no hope of coming back decisions. One thing that I like to put in there is a provision where you can state your wishes And you get to choose whether the person that you've nominated must follow your decisions or whether they have some leeway at that time to discuss with the doctors and see what the best option may be at the time. A HIPAA authorization confers no medical decision-making authority. This document allows access to your medical records, allows the person or persons that you name to have conversations with your medical team, to call and check in on you if you are in the hospital. And a great thing that lots of people don't consider is having HIPAA authorizations for children that are going away to college. Some of you may be at that stage of life where your kids are going off. And for example, if they're over 18 and something happens at school, you are unable to call and check on them. We recently had something similar happen with a nephew of mine who was injured playing basketball in college. And unfortunately, my sister and his mother did not have a HIPAA authorization. And so until he was able to confer to the medical team that they were able to speak to his mom, she couldn't receive any information or find out how he was doing. So that's a good thing to remember. Whenever you're sending your children off to college, have them sign a HIPAA authorization, allowing you access to see how they're doing. In either a will-based plan or a trust-based plan, we include a personal property memorandum. This is a document, while not a legal document, it is referenced in both the will and the trust so that you can distribute your engagement ring, grandma's china, your dad's grandfather clock, those special items that you want to give to individuals. This allows you to list that there, and you can sign it and date it. In the event that you change your mind or circumstances arise where maybe you don't want Johnny to have your grandmother's china, you would like to give that to Sally instead, you can come back to your personal property memorandum, scratch it out, change who you want it, sign it and date it, and the last dated personal property memorandum wins, right? So what is great about that is that you can make those changes as they arise without calling me, having to come in, re-execute your will or your trust or do codicils to it, and allows you to make those changes easily. You will recall that when I was discussing trusts, I mentioned that there were some assets that could not be placed into the trust. And with those assets, we would make sure that your beneficiaries are up to date. For this part of the discussion, I'm going to bring Neil back in, and he'll discuss those options with you. It allows for comprehensive planning between financial advisors and your estate planning attorney.
Thank you. Thanks, Ann. That was a lot of really important and great information. I know it can be overwhelming sometimes. We make it simple for our clients. Just know that there is a way to make this manageable for you to feel more confident and organized around all of these areas. One of the things that I notice a lot as a wealth management firm is we meet with people all the time who have these beautiful estate documents, trusts, wills, other documents, but it never really translates to the ownership and beneficiary designations on their assets. And whatever your ownership and beneficiary designations are, that's always going to supersede whatever documents you have. My wife mentioned earlier how a trust is like a treasure chest, so to speak. Well, oftentimes people have that treasure chest, those trust documents, but they never retitle their assets, so those trust documents don't do any good. Part of working with a full team of advisors, estate, tax, investment, is that we make sure all these areas are coordinated. I can't tell you how important it is to have all of the team members for yourself, for your wealth management, all on the same page. Let me give you another example. So recently we met with someone who had created this beautiful trust to help protect her assets from Medicare costs, or I should say long-term care nursing home costs. She spent a lot of money on these trust documents, and then she came to see us, and what we noticed was that all of her assets were in IRAs. Now, what she didn't realize, and because the estate attorney wasn't on the same page with the financial advisors, was that that trust document, it can't protect those IRA assets because you can't retitle an IRA to a trust without yanking it all out and paying taxes on it. So that time and effort and cost really did her no good. And that wouldn't have happened if she was with us. So another thing that I can tell you is that a lot of clients, they go to the expense of creating trust to avoid probate. And I think that's really important, especially if you have things like real estate or even your home. But sometimes what you'll find if you're working with the right advisor like our firm is that you can have the right beneficiary designation set up on your non-IRA assets, for example, that will totally bypass probate. That's called transfer on death agreements. Some call them payable on death agreements. Again, just understanding what assets are subject to probate and which are not, and then having a coordinated approach to protect you for both types of assets. Next thing I want to talk to you about is taxes. You know, I have a passion around tax planning. I've owned a tax planning firm in the past. I have CPAs and other tax professionals on my team. And what I can tell you is that oftentimes it's overlooked in the estate planning process. So even though there's thousands of types of investments, maybe tens of thousands, there's only really 3 ways your investments are taxed or not taxed. That's either tax deferred, which would be something like your IRA or 401k. There's tax free, which would be something like a Roth IRA. And then there's taxable accounts, which would just be like a joint brokerage account, for example. So a lot of the planning we do for clients is around proactive tax planning to minimize their taxes, but also to minimize the taxes that their kids pay, for example, when they inherit things like mom and dad's IRA. So let me give you an example, and I just ask you to follow me here. But IRAs, traditional IRAs, when your children inherit that money, for example, it's fully taxable to them as income. So if we just assumed mom and dad worked really hard and accumulated $1 million in that traditional IRA, and let's say that passes to their 50-year-old daughter and she happens to be in her prime earning years and is in a high tax bracket, she could lose hundreds of thousands of dollars in taxes. Now, some of the planning that we do for our clients is when does it make sense to take some of that fully taxable IRA money and convert it to a Roth IRA? Now, if mom and dad are in a very low tax bracket, it might make sense to take significant amounts of that IRA and convert it to a Roth IRA, a Roth conversion IRA over time. That can actually provide mom and dad some tax benefits because Roth IRAs don't have those forced or required distributions like traditional IRAs. And then ultimately, let's say they convert $500,000 and that $500,000 over 20 years grows to $2 million. Well, that $2 million might pass to their daughter, in this example, income tax free, saving her hundreds of thousands of dollars possibly, as opposed to fully taxable, costing her hundreds of thousands of dollars. So that's just one example of why it makes sense to have the estate planning attorney on the same page with your tax strategist, on the same page with your investment person. And just to take a step back, I like CPAs, I work with CPAs, I have them on my team, but most CPAs are just looking in the rearview mirror. Very few are doing the proactive tax planning like Roth conversions, let alone sitting with your estate attorney and your investment person. And that's one of the main reasons people hire us, is for that coordinated effort. So I just gave you a couple examples. Estate planning is not hard. You've taken a great step today. If you're with us this far into this presentation, I think that's great. I mean, that's more than most people will do. So it isn't hard. You just have to get started. And we really try to make it easy for you. On this video you're receiving via email, most likely, there's going to be a link to download estate planning information directly from our website. there's going to be a link to schedule a complimentary short meeting with one of our team of professionals to determine if it makes sense to have a longer discussion and who that longer discussion should be with. So why now? Why us? I don't know about you, but this was my first global pandemic. I've never thought more about death and planning from a healthcare standpoint than I have these past few years. The tax situation, the tax landscape is more complex, I believe, than it's ever been. Just within the past 5 years, we've seen Secure Act 2.0, and many other changes to the tax landscape. And oh, by the way, in 2026, a lot of these tax benefits that we're receiving now, whether you realize it or not, may go away because they're sunsetting or getting rid of a lot of the provisions of the 2017 Tax Cuts and Jobs Act. Now, again, it's a lot of information. This is the kind of things that we cover when we meet. So why now? Well, because none of us are getting younger. Healthcare should be on your mind, and the tax landscape is more complex than ever. Why us? Well, I've been doing this for close to 30 years. I am a fiduciary, legally bound to do what's in your best interest. I work with people with complex needs who want a proactive tax planning approach combined with sophisticated investments, an objective insurance analysis, and obviously the estate planning integration. So you're going to see on your screen, there are some additional items to consider with respect to our team and our background and our designations. There'll also be a link to our websites to check us out and read our reviews and to do all that research. We hope you do. I really appreciate your time today. Again, let me just encourage you to, at minimum, get some more information from us. Don't let this past 45 minutes or half hour or an hour that you've spent here go to waste. Visit our website, get some additional information, schedule that short meeting with a qualified member of my team to discuss your specific concerns and goals. We do work primarily with what we consider successful individuals, families, people who have need for this type of integrated approach, taxes, estate, insurance, investments. That's who we serve best, and that's who we hope to meet with. Once again, here's our process. Number one, schedule that short phone call with a member of my team. From there, they will determine, you know what, maybe you don't need anything, you got your questions answered, and that's great. We wish you the best. We're here to provide you information. Or two, based on that conversation, they determine, you know what, your needs seem to be very narrow, and maybe you just need to meet with another estate planning attorney in the area that we know, and that's okay too. Or maybe you would like a team helping you with all these areas. Those are the three options that we'll determine from that short phone call and give you guidance on what we think makes the most sense for you. I thank you so much for listening today. We had a lot of fun. We really appreciate the opportunity to help educate the people we care about in our community around these important aspects, and we hope to see you soon. Thanks again. Bye-bye.